Okay, I'm Judge Eisnagel. I'm presiding this morning. Welcome to an oral argument session on Zoom of the 5th District Court of Appeal. On the panel, we also have Judge Harris and Judge Wozniak. Before you get started, if the appellant could let me know how much time you'd like in rebuttal, I'll do my best to remind you when we get to that point.
Sure. Good morning, Your Honor. Robert Sowell of Baker and Hostetler on behalf of the appellants. And I'd like to reserve 5 minutes, Your Honor.
Okay. Like I said, I'll attempt, you need to watch the clock as well, and I'll try to help you remember. And with that, the appellant, whenever you're ready, you can begin. I'm sorry, I should say the case number. It's case number 20-2322, DTR versus MHP Management. You may proceed.
Thank you, Your Honor, and may it please the court. This appeal concerns Florida's forum nonconvenience doctrine in the trial court's dismissal of the case below, not because Florida is an inconvenient forum, but merely because another forum is also convenient. This, of course, is not the test under Florida law. And in so holding, the trial court committed reversible error and abused its discretion specifically with respect to the second and third Kinney factors. 3 of these errors, Your Honors, and what will be the focus of my argument today, relate solely to legal errors and the trial court's failure to apply the correct test. First, the trial court did not apply any deference in favor of the appellants who were the petitioners below choice of forum. Second, the trial court flipped or inverted the forum nonconvenience test, thereby removing the burden from the defendant and placing it on the plaintiff. And third, the trial court disregarded the public interest based solely on MHP, the appellee's preference to litigate elsewhere. Your Honors, in addition to these legal errors, we also contend that even if the trial court had applied the correct test, though it didn't, the record does not support any reasonable conclusion that either the private interest, the second Kinney factor, or the public interest, the third Kinney factor, could favor dismissal. In fact, MHP did not submit any evidence in the trial court that Florida is inconvenient to it. There is no witness testimony, there is no affidavit, and there is no documentary evidence to show that Florida is an inconvenient forum, and that is the test. So as to the first error committed by the trial court, Your Honors, the trial court failed to apply any presumption, let alone a strong presumption in favor of the plaintiff's choice of forum.
But counsel, the trial court's order says that it did apply the presumption. And it sounds like from the trial court, it applied the presumption, but then found that still it didn't apply. How do you get around that?
Well, Judge Wozniak, let me answer your question directly, and then I do want to go a little bit into the background and how the presumption operates. But here we know that the trial court, though it said it did not apply the presumption because it found that none of the private interests rendered Florida to be inconvenient. That being the case, to have applied the presumption, that scenario should have foreclosed dismissal. Specifically on page 612 of the record, the trial court held that interests related to witnesses and evidence were irrelevant, that interest related to enforcement of judgments was irrelevant, and that the practicalities.
So how is enforcement of judgments irrelevant? Won't this, assuming that you lose, wouldn't the judgment need to be executed in Delaware?
Well, no, Your Honor, we would agree with the trial court that enforcement of judgments is not relevant. There's no money judgment here, and there's nothing that requires that it be
control. It's for control of a Delaware company, correct?
That's correct, Your Honor, but that entity has since been dissolved, and what we're fighting about here is payout. But to enforce a judgment, it certainly doesn't need to be brought in Delaware. It would need to be brought where all the individual entities are located. And none of the entities in this case do any business in Delaware, have any location in Delaware, have any employees, offices, or even lead counsel in Delaware.
So even though the control of the entity at issue is a Delaware entity, you wouldn't need to have a domestication proceeding in Delaware?
No, you wouldn't, Your Honor.
Why not?
In fact, because what an enforcement proceeding looks like in this context, and again, it's not a money judgment scenario, what it looks like in this context is that they believe they now have control over the entity, which is nonetheless dissolved. They would need to go to, let's say, DTR, MHP Management LLC's forum and say, we need an injunction to get you to stop acting on behalf of this entity. They've already bought that case in Colorado. Conveniently, they've left that out of their papers. So we already have a quote unquote enforcement proceeding. And it wasn't in Delaware. There's no reason for it to be in Delaware, regardless of whether we're fighting about control of a Delaware entity. In fact, on pages 3 and 4 of their answer brief, MHP contends that MHCA Management, the Delaware entity, shouldn't even be a party to this proceeding. So back to the presumption, Your Honor. The only thing that the trial court found on the private interests were that they, quote, do not weigh against Delaware. Now that, of course—
Is it your argument, Mr. Sell, that the trial court did not give any deference to plaintiff's choice of form or did not give sufficient deference?
Our argument—
Because as Judge Wozniak said, it is covered in the judge's order that he considered the plaintiff's choice. Are you saying he didn't give it enough deference?
Judge
Because
Harris,
there is a sliding scale, right? And if the judge found nominal context, then you get less deference than you would otherwise, if it's a forum shopping type finding that the trial judge made.
Well, Judge Harris, you made a couple points there that I want to address head on. One, our argument is that he did not apply any presumption. And I want to direct this court to the SME Racks case, which states where you have a scenario where the trial court did not find that any of the private interests rendered Florida to be inconvenient, quote, by definition, the plaintiff's choice must win if all other factors are to be created or all other factors are equal. So for the trial court to have applied the presumption and for us to consider this under an abuse of discretion, he would have had to have found that the private interests rendered Florida to be inconvenient. That's the test. He did not do so. And I want to direct the court back to that SME Racks case. That's an 11th Circuit decision that's specifically relied upon by the Cortez case. In that decision, the 11th Circuit rejected the mere fact that the trial court, the United States District Court of Appeal, referenced the presumption or said it was applying it. Instead, the 11th Circuit looked to the trial court's actual analysis. And when it did so, it said, no, you failed to apply the presumption, trial court. What you did instead is you merely balanced the two fora. That's not the test. And Judge Harris, one other point you made, which comes from MHP's answer brief, is that their contention that this is a sliding scale, the presumption is a sliding scale. It most certainly is not. That is not Florida law. There is nothing in Cortez that says that. Cortez makes clear that the presumption, quote, always applies unless the one exception where you have a non-US plaintiff. And what's telling is that for this proposition, they cite to case law from the United States Court of Appeals for the Second Circuit. They don't cite to any pre-Cortez decision applying a sliding scale. The Second Circuit applies a three-step test that is completely different from the Kinney test. And once more, in both of the Second Circuit cases on which they rely, you have a non-US plaintiff, which is the one exception identified by the Cortez court. The other case they cite actually is a Florida case. It's the Lloyds of London case, but that again involves a non-US plaintiff, which is the one exception identified by Cortez. None of these cases can overcome Cortez. Cortez says we always apply a presumption, and it's a strong presumption. The only time we don't apply a presumption is when you have a non-US plaintiff coming into the United States, specifically in Florida, and suing someone else.
So DeLuca doesn't say that presumption is lessened if there are nominal contacts with the state. That's a Florida case, isn't it?
Well,
or am I misremembering?
DeLuca predates Cortez by some years. And in addition, that case can't even be squared with the Second Circuit cases that MHP cites because it faults a plaintiff for filing in their home forum. You can't have it both ways. The Second Circuit cases they cite say that when that scenario happens, we know that it's a convenient forum. And in fact, the Pollux case that they cite says we know that there is no quote unquote forum shopping when you have a plaintiff going into the defendant's home forum to ensure that it has jurisdiction.
Counsel, tell me about, tell us a little bit about cases analyzing the issue where the case has already been substantially litigated, elsewhere. Many of the cases are the initial complaint was filed and we're arguing over the forum for the initial complaint. In this case, it's sort of unique because you have substantial litigation, and essentially, this is this filing is for review of an arbitration trial, right? Essentially, so I mean, does that matter? I mean, are there any cases addressing the situation where it's already been heavily litigated in another forum?
Well, Judge Eisnagel, 2 points. One is that the Kotzak and the Lewis and Pete case that we cited, Florida courts have no problem with parties that are involved in arbitration elsewhere coming to Florida to either vacate or confirm the arbitration award. 2, the fact that all we're fighting about here is vacature or confirmation of an arbitration award means that the fact that they're located in Florida is all that matters. It cannot be inconvenient for them to have to litigate in Florida, and that's the test. Because
there's no doubt. I mean, I don't know that anybody's disputing that Florida is a proper forum, that it's there's jurisdiction and all that stuff. So I think the question is does that affect the forum nonconvenience analysis, and if so, how?
Well, again, Your Honor, the forum nonconvenience analysis is whether Florida is inconvenient. Full stop. Now, what we're doing here is fighting about.
But you compare it to the convenience. Don't you have to compare that to the other forum when you're looking at, is Florida inconvenient? I mean, litigation is inconvenient, right, counsel? It's always inconvenient, but don't you have to have something to measure it by? So don't you measure it by comparison? No.
Well, Judge Eisnagel, that's a great conceptual point. And to determine whether Florida is inconvenient, we obviously have to compare it to something. But at the end of the day, the test is still whether Florida is inconvenient. This is not a raw balancing test. So let me give the court a hypothetical.
How do you jive that with the beginning part of 1.061 that says the court can dismiss it if it finds that another jurisdiction will be more convenient? It doesn't say that Florida is inconvenient. It doesn't need that finding. Just in this case, Delaware would be more convenient.
Judge Harris, 2 points. The commentary to the rule says we have to look at Kinney in interpreting this rule. And Kinney says, as interpreted by Cortez, that the rule is whether Florida is inconvenient. And the second point, which is escaping me, Your Honor, is that I want to go briefly back to Judge Eisnagel's point. The parties agreed that the arbitration would take place in Delaware. That's 14.1 of the operating agreements, page 87 of the record. However, in section 14.3, page 80 of the record, the parties then agreed that we can go anywhere to hold the vacature or confirmation proceeding. And Judge Harris, I want to go back to your question just briefly. If this is a raw balancing test, which is how MHP seems to treat it, then in any scenario, the plaintiff is put against the ropes because a defendant can come into court, offer up a miscellaneous alternate forum, and demand dismissal unless the plaintiff comes forward with evidence to prove that this alternate forum is inconvenient. At the end of the day, forum nonconvenience test is whether Florida is inconvenient. Cortez leaves no doubt about this. It characterized this as the whole premise. That's why Florida courts, including this court and including the Florida Supreme Court, have come to label efforts by at-home defendants, which is what we have here, to invoke the forum nonconvenience doctrine as, quote, puzzling, quote, strange, exceptional circumstances, because a party that's located in Florida cannot claim that Florida is inconvenient to it. And the way the test works is that we don't just balance the two forum. That was the issue in SME Rex. That's the issue.
If you could, though, before you get to any rebuttal time, could you go back to the language you said, you quoted from the operating agreement that says the parties can choose basically any jurisdiction. What precisely does that language say?
Well, Your Honor, it says that the parties can enforce a judgment in any court of competent jurisdiction.
Enforce, right? You're not seeking to enforce. Does that make a difference?
Well, Your Honor, we're asking for a judgment of vacature and they're asking for a judgment of confirmation.
But they filed theirs.
They're both judgments. I know they make the argument that what we're asking for is not a judgment, but that doesn't make any sense. Frankly, I don't think the court should really give that argument much lip service. What we're asking for is in judicial labor in this case will be the arbitration award is vacated. And we think that argument has merit. And then just very briefly before I reserve the rest of my time, the third issue that the trial court erred on relates to the public interest. And the trial court said that because MHP does not want to be in Florida, the public interest can be disregarded. That cannot be the law. They don't get to choose one way or the other whether the public interests favor or disfavor Florida. It's not a choice to be made. I mean, with that, Your Honor, I'd like to reserve the rest of my time.
Thank you, counsel. Counsel for the appellee, whenever you're ready.
Thank you, May it please the court. Michael Crosby with Shetson Bowen. Appreciate your all's time. Hopefully there will not be a cat jumping on my lap like the last time I was in front of Judge Harris. So let's kind of take a broader picture.
Counsel, it does seem like that, when you're just reviewing the order, there is some merit to what your opposing counsel is saying, that it seems like the trial court simply considered whether or not Delaware was inconvenient. There's not a lot in there to suggest that, well, hey, Delaware is both convenient and Florida is inconvenient, or am I missing it?
Well, I think you have to take into account the papers, the underlying papers that were filed, the arguments that were made. I can't read the judge's mind, but those arguments were all addressed during the hearing on the motion to dismiss. And the point we made was geographically, it's easy for me if I were counsel of record in the motion to confirm case, but I'm not. Both parties already have counsel in Delaware. And it's important because it's a Delaware company. It was a Delaware panel. It was a Delaware arbitration conducted by, and the chair was a former Delaware judge. The operating agreement's a Delaware operating agreement, and it's governed by Delaware law. And so when we filed, I think 6 days after the appellants filed their motion to vacate, when we filed the motion to confirm in Delaware, we did it in Delaware because it makes sense. That's every connection to this case is Delaware, with the exception that my client was formed in Florida, and that is it. And the trial judge recognized that.
But why, certainly Florida courts are capable of applying Delaware law, right? I mean, why is that so compelling in and of itself?
Well, absolutely. The Florida courts are capable of doing it. If we're talking about the public interest of, do we want, Florida judges to, spending judicial resources to resolve what is truly a non-Florida dispute? That's point one. Point two is there are differences between Delaware law and other law in connection with the underlying unsuitability determination. In Delaware, the law is that if my clients had a subjective good faith basis to deem the appellants unsuitable, or 3 of the appellants unsuitable, then the standard is good faith means the absence of bad faith. That's the law in Delaware, and that is not the law everywhere else. So the suggestion in the appellate's papers that this is Hornbook law is simply not correct. Plus, if you look at their 46-page complaint in this, in their petition, the trial judge, if it's kept here, is going to have to get into all sorts of issues about the underlying arbitration and the underlying facts. There were 433 exhibits. It was a 7-day arbitration. Mr. Sal was there. I was there with him. We stayed in the same hotel. And it went over the weekend. And then we followed it up with post-hearing briefing, and then we went back to Delaware, which was
But
not.
counsel, everybody doesn't everybody agree that witnesses aren't an issue here?
Witnesses are not an issue. Evidence is not an issue. Site location is not an issue. Enforcement of a judgment is not an issue. Accessibility to a court is not an issue. All those private interest factors, no issue.
Let's focus on private interests. Again, if we're looking at the order, the order itself doesn't really make clear why the private interests weigh in favor of Delaware. Give us the best argument why the private interests weigh in favor.
Well, the private interests weigh in favor of Delaware because it's Delaware law, it's a Delaware company, it's a Delaware panel, and that is frankly, from both parties' perspective, or from all parties' perspective, that is the thing that drives the private interest. I can assure you the appellants did not file this case in Florida to make it convenient for my client. It's just.
But specifically, what is inconvenient about Florida? If witnesses aren't an issue, site location, all that stuff. I mean, and if Florida courts can apply Delaware law and et cetera, what specific points are there that make it inconvenient for your client?
Well, if you just look at the timing, the 54-page arbitration award came out, I think, in March 2020. The appellants moved to vacate it in June 2020, if I've got my dates right. The trial court couldn't hear the motion to dismiss until October 2020. And here we are in June 2021. We all know it's the Florida courts are overwhelmed, but this is a private interest. There's a backlog, they're overwhelmed. In Delaware, it is a summary proceeding. Delaware deals with this all the time, and that is far more convenient, which makes Florida inconvenient to my client to resolve this timely, because Mr. Sal's right. My clients filed through another counsel an action in Colorado to enjoin the appellants from continuing to act on behalf of MHCA management, which manages a fund that has approximately $200 million in property. And they are acting as if they are in control when they were removed September 5th, 2018, pursuant to the unsuitability determination. Now, if I can refer to Cortez, and apologize for reading, Cortez citing Kinney says forum nonconvenience is a common law doctrine addressing the problem that arises when a local court technically has jurisdiction over a suit, but the cause of action may be fairly and more conveniently litigated elsewhere. Forum nonconvenience also serves as a brake on the tendency of some plaintiffs to shop for the best jurisdiction in which to bring suit. And that's what we have here. It was a race to the courthouse. They beat us because they didn't have to retain counsel in Delaware to do it. And so they raced here and they got here. And despite it being geographically good for me because I can walk to the courthouse, it is inconvenient in terms of learning curve, history, and the application of Delaware law. And so I hope that answers your question.
Thank you, counsel. I'll ask you this too then, unless if another member of the panel has a burning question, feel free to interrupt me. What do the cases say? I mean, a lot of these cases, as I said before, relate to a brand new complaint, the very beginning of the litigation. Obviously, this one has been heavily litigated before and in a different forum. Does that affect our analysis? And if so, how? And if you could cite some cases, that'd be great too.
Well, I've got to tell you, I don't recall seeing one. I've got a little bit of COVID brain, but I do not recall reading a case that dealt with an arbitration that had been decided and there were competing claims and competing jurisdictions on how to resolve it. But it seems to me from a practical perspective that to the extent judicial labor needs to occur, it should occur in the forum where the case was heard and the parties agreed to arbitrate. There was a question earlier about, did the operating agreement say the parties agreed to litigate anywhere? That's just not the case. It was to enforce a judgment. So there's should be no weight given to the notion that this is an attempt to enforce through a judgment an arbitration award. If, for example, the appellants had prevailed and they had gotten a money award, I wouldn't be making this argument. We wouldn't be here because the operating agreement is clear, but it's not on this. It provides no guidance on where to seek a vacatur. And so to answer your question, kind of a long way, I'm aware of no case that discusses a post-arbitration forum non-convenience argument.
I guess what I'm struggling with is the presumption, right, in favor of a plaintiff's choice of forum makes a lot of sense when it's at the beginning of a brand new case. I just wonder if there's any analysis out there on how that presumption might change or not change when it's sort of the filing is after a substantial amount of litigation elsewhere.
Well, I think, in referring back to Judge Harris's comment about the sliding scale, and you could take it probably a step further, there's a absolute minimal connection with Florida, which renders the strong presumption that the trial judge mentioned far less important. Add to that the fact that the case was heavily litigated in another forum. There's no attempt to collect a monetary judgment. There's no issue with evidence or witnesses or anything of that nature. And I think that would suggest against, giving extraordinary weight to the presumption of the correctness of the forum.
What was the connection to Florida besides MHP Management being a Florida LLC? Because the underlying business was nationwide, right? Is there any other connection to Florida?
No, I mean, no. With respect to MHP, the principals live here. But who cares? That doesn't matter. That's it. In fact, I don't know that the ultimate fund that holds these properties had any properties in Florida at the time of the dispute. As the trial judge found, the only connection to Florida is that MHP Management LLC was formed here.
Counsel, can you have anything else? I mean, you've already addressed it to a substantial degree, but anything else on the public interest factors?
Well, yeah, I mean, the public interest factors, I think it was not equipoise. It was not that the trial judge disregarded them. They clearly favor going to Delaware to resolve this. Kenny talks about it and Cortez talks about it, that, Florida is not the world's court, and cases that have little to no nexus with Florida, although there technically might be jurisdiction, shouldn't be resolved using taxpayer money and judicial resources. Plus,
Counsel, go ahead.
I would say, plus we've got the application of foreign law, Delaware law. Plus, we stipulated during our hearing with the trial court that we wouldn't raise a statute of limitations defense, a jurisdictional defense, if they wanted to tack on their motion to vacate to our petition to confirm in Delaware. And the judge notes that at the closing of his order, that I think the case law and the rule require us to.
I'm going to say, you don't get any points for stipulating, right? Doesn't the rule say you shall be deemed to have stipulated?
We did, and we're also deemed to have stipulated. So the public interest, I think it weighs heavily. And the other thing I think is Cortez expands on Kenny, because, and I might have a quibble with our trial court's order to the extent that it says, go to step one, there's no issue. Go to step two, I resolve that in your favor. So then I go to step three. Cortez seems to suggest that when you're doing this analysis, you have to look at the public interest. You have to take that into account. And it's not entirely clear to what extent, because Cortez also talks about the strong presumption. But I think it's perfectly appropriate, and it's what our trial judge did, to look at the public interest, to say this case has nothing to do with Florida. And I'm gonna send it to Delaware where it does have a connection.
Counsel, just so we're clear on it, what the private interest factors, if you're let's say the trial court concluded that your client, that those actually weighed in favor of Florida, is the analysis over, or can you still win if the public interest factors weigh heavily enough in your favor?
Well, I think I think Cortez suggests it might, but I mean, candidly, it would be a much tougher argument for us if he said all the private interests weighed in favor of the appellants. But the difference is Judge Alvaro, and again, I can't get in his head, but said he considered everything, including the strong presumption, and he concluded that the interests were at equipoise. And I'm not one to question the trial judge's ruling. I think he thought it through, and he wrote what he said. And that was not an order that was prepared by the parties, by the way. That was the judge on his own preparing that order. So I don't know about that hypothetical, Your Honor.
Any other questions from the panel? Counsel, you're free to address any other issues. You still have 4.5 minutes left. Or you can waive your time. It's up to you.
I think maybe I would respond to a couple of points. The notion that this entity, MHCA Management, has been dissolved is not accurate. On September 5th, 2018, when the unsuitability determination happened, the operating agreement says the members who were deemed unsuitable were automatically removed. Any actions they took after that, including purportedly to try and dissolve the company, were of no effect because they were not members. We did assert in the answer that MHCA Management should not be a party to the appellant's case. Again, that's because they were removed as members, unless the court tells us otherwise. The arbitration panel found they were removed as that the unsuitability determination was valid. And so that is why we said MHCA Management should not be the case. And then in terms of, I guess my final point, I'm not going to burn up all my time, is the trial court wrote this order, and there's a case, and I can't remember we cited it in our brief, but we can't expect our trial judges to write 40-page orders detailing everything that crossed their mind in reaching these conclusions. It's a detailed order that covers all 4 points. It glosses over nothing. There's a transcript that backs it up. And I think what the appellants want to put a burden on the trial court to more fully articulate in writing the rationale. The judge, I think the judge could have just said the motion's granted.
Well, counsel, the appellants did argue in their brief that we should reverse because there are inadequate findings, but as best I could tell, that argument wasn't preserved. The lack of findings.
I'd agree with that. I mean,
did they ever raise that below and give the trial court an opportunity to make the findings?
No, unless Mr. Sal's got something to point out. No.
I mean, usually that would come in a motion for a hearing.
Yes, and again, to my distinct recollection, there was no motion for rehearing or motion for reconsideration or whatever you want to call it.
Okay.
I have nothing further to add. My outline's now shot, so I'll waive the rest of my time.
Thank you, counsel.
Sure.
All right, and counsel for appellant, you have 4 minutes and 43 seconds. You can proceed whenever you're ready.
Thank you, Your Honor. Judge Eisnagel, you asked my friend, what is inconvenient about Florida? He had no answer to that. he started talking about Delaware.
Well, was there any evidence? Was there anything? What was presented to the trial court below? Anything?
None. There's no evidence. In fact, they didn't even argue that Florida was inconvenient. And of course, they like to characterize Florida as merely the place of its formation. Florida is not merely their repository of corporate documents. Florida is its home forum, its principal place of business, the location of its manager's place of formation, its manager's place of business, the location of Jamie and Ryan Smith, its ultimate principals. In fact, its offices are blocks away from the Orange County Courthouse where this case was filed. The Orange County Courthouse is also
Mr.
blocks
Crosby said
away.
you didn't file this for their convenience. That's not why you chose Florida. I mean, you're trying to get a court to vacate the decision of a 3-person Delaware arbitration panel, including a Delaware judge. You didn't choose Florida because it was so convenient for Mr. Crosby's clients.
Judge Harris, respectfully, we absolutely chose Florida because it is convenient. Let me talk about another case that mirrors this arbitration proceeding. The trial judge said this didn't matter, but it actually does. There's another arbitration proceeding pending in Florida between the exact same parties, involving the exact same operating agreement and involving the same provision under the operating agreement. In that case, the parties agreed to do it in Florida before, among other arbitrators, former Circuit Judge Underwood, because Florida is substantially more convenient and because we don't want to have to go back to Delaware and, as Mr. Crosby pointed out, stay in a hotel, hire a local counsel, and jump through all those hoops again. And importantly, they agreed to litigate that case in Florida before they began trying to get this, before this case was filed and before they began trying to get this case out of Florida.
Counsel, would the private interest be a tie in your view if it weren't for the presumption that weighs in your favor? Would it be a tie?
No, Your Honor. We think that the ties to Delaware are minimal when compared to Florida, but
well, why is Florida
subject to an abuse of discretion? And so
why is Florida? Tell us why Florida is more convenient. Without the presumption, you say you still win the private interest. Why? Because
there's an actual party here, a real party in interest.
But the entire trial happened in Delaware. It was a Delaware panel, right?
But Judge Eisnagel, that doesn't have any bearing on convenience. Mm-hmm. Just because it happened in Delaware doesn't mean that we now have to go back to Delaware. It's not that there's witnesses and evidence in Delaware. It's not that the exhibits are being stored in Delaware. What we're doing here is challenging an arbitration award. It's effectively putting the award before the trial court here and saying, we think that this is subject to vacature under the Federal Arbitration Act, not the Delaware Uniform Arbitration Act as they contend. And the test that will be litigated before the trial court here is whether we can meet our burden to show that the arbitration panel exceeded its authority in interpreting or rewriting the operating agreement as we contend. Judge Wozniak asked at the beginning of my presentation about how do we know that the presumption was not applied? And then Mr. Crosby discussed, I can't get into Judge Alvaro's head to determine whether or not he found Florida inconvenient. But this is not a scenario where we need to comb the record, and we're not asking this court to comb the record to see if the trial judge correctly found Florida to be inconvenient. We know that he applied the wrong test because he says he applied the wrong test. He says, quote, do not weigh against Delaware, and that flips the test. And Your Honor, I want to go back to the Cortez case, and I want to read a couple of lines from Section 2, and I know my time is running out. I'd read the entirety of Section 2 for this panel, but I don't have enough time. There, the Florida Supreme Court states, in Kinney, this court adopted the rule that a plaintiff's choice of form is entitled to a strong presumption. We did not limit this presumption in Kinney to Florida plaintiffs or indicate in any way that the policy behind this rule would automatically be eviscerated by applying it to out-of-state residents. Indeed, it is axiomatic that the plaintiff has the right to choose the forum. Thank you, Your Honor.
Thank you, counsel. Before we conclude for the day, let me say that the briefing on both sides in this case was excellent. The argument on both sides in this case was excellent. Both counsel did a fantastic job with an interesting issue. Thank you very much for that. And with that, we are adjourned.